call to order the meeting of the Federated City Employees Retirement System and Federated City Employees Healthcare Trust, Thursday, April 15th at 8:31 in the morning. So let's start with the roll call. Vice Chair Horowitz.
Present.
Thank you. Trustee Chandra.
You're present.
Thank you. Trustee Jennings.
Present.
Thank you. Trustee Kelleher.
Present.
Thank you. Trustee Orr.
Present.
Thank you very much. And I'm here, so that makes 6 of us. First thing on the agenda is closed session. So we will be moving into closed session, and we anticipate coming out at around 9 o'clock. So let's go ahead and move into closed session. Just a reminder, staff isn't able to put the trustees in the closed session room the night before, so we'll just wait as they move us in one at a time. So we are returning to open session. Thank you everyone else for your patience while we were there. Let's orders of the day. Are there any changes to the agenda? I don't show any. I don't show any sunshine exceptions. We ready to move forward? I'm planning on a break at 5, just after 5B, which is the oral update from the City Council liaison to the board, and just before we jump into the discussion sessions on disability retirement. Roberto, does that sound about good?
Whatever your pleasure is, Mr. Chair, sure.
Okay, all right, very good. All right, let's move on then to item 1, the consent calendar. Today's consent calendar includes approval of service retirements, approval of deferred vested, approval of board minutes, approval of return of contributions, acceptance of communication information reports, approval of travel conference attendance. Is there anything to be pulled? If not, I'll accept a motion in a second to approve the consent calendar.
All motion to
Approve.
approve.
Oh, pardon me.
Sure.
Motion from Trustee Kelleher, and is that a second from Trustee Orr?
Yes.
Yes, thank you very much. Good. Any discussion? Let's do the roll call vote. Vice Chair Horowitz.
Aye.
Thank you. Trustee Jennings.
Aye.
Thank you. Trustee Kelleher.
Aye.
Thank you. Trustee Orr.
Aye.
Thank you. I also vote aye. That motion carries unanimously, 5-0. All right. Item 2 is death and survivorship notifications. At this time, I'd like to ask for a moment of silence for those who served the city and have recently passed. Thank you, everyone. All right, moving on to item 3. 3 is the oral update from the CIO of Retirement Services, Mr. Polani.
Thank you, Mr. Chairman. We really have no agenda items to discuss today, but I did promise the board last month. So the board approved the healthcare trust allocation, and we said we would implement on the board's suggestion that we will actually pace the allocation to fixed income. And so I'm going to ask Senior Investment Officer Jay Kwan to discuss implementation of the healthcare trust allocation with the board now. But just before he gets to that, I just wanted to share some performance numbers. And as always, these are unaudited numbers. For the month of March, the pension plan returned 1.05%. And as of the day before, and that's the last available date, was actually April 13th, our fiscal year to date performance for the pension plan was 22.35%. And so again, these are unaudited numbers, and the numbers are looking good compared to our discount rate. But as always, anything could happen between now and June 30th. With those comments, Mr. Chairman, with your permission, I'd like to turn this over to Jay Kwan.
Please, and thank you very much.
Good morning. If we could open up the attachment 3A. Sorry, Linda or Michelle, did you need me to share the screen? It's just one page. If you could throw that up.
Yes, yes, please. We did not know that we were to share your page.
Okay, if you don't mind enabling, I think I'm a participant in this particular meeting. Great.
Should be able to share now.
Thank you. Okay, sorry about the little hiccup. At the last board meeting, you all selected a new allocation for the healthcare trust. And as part of that discussion, as probably noted, there was an agreement to implement the new allocation incrementally. And I believe it was Laura's suggestion from Makita who made the eminently reasonable suggestion to leg into the new changes. And so that's that's what we've put up here on the screen. It's this sheet has a lot of numbers. It's a little bit complicated, but we're just going to walk through it and we can read it hopefully in a straightforward manner from left to right. So on the left, we have our current allocation labeled target weights, which you can see conveniently adds up to 100%. The column next to it labeled index duration shows the duration or weighted average maturity of the fixed income indices. So I made the kind of simplifying assumption here that the non-fixed income indices have a 0 duration, which of course isn't exactly true, but for the purposes of this particular exercise, it's probably a fair assumption. So next to the target weights, there's a column labeled CTD. That's contribution to duration, and that's just the duration of the index weighted by our target weight to that particular asset class. So that's how we're measuring for a particular allocation. So for a particular column, we're measuring the duration at the plan level. And so that's summed at the bottom there, where you can see the weighted duration from fixed income for our current target weights is very low. It's 0.07 years. And so the subsequent columns here are just the incremental steps we're going to take to leg into our ultimate target allocation on the far right. And that's the mix A that was approved at the prior meeting. The first column, so at the end of May, we're penciling in that we make the changes across the equity and real estate exposures and partial changes across fixed income. All right. So you can see then the result of that with regards to duration in the CTD column for May, we're adding about 0.6 years to the plan. The next tranche in July, so 2 months after, we're going to make an additional set of changes across fixed income. The net result of that is again an increase, so another incremental step in the duration of the plan of about 0.6 years. And so we tried to kind of evenly leg into the overall changes in duration. And we finish at the end of September, legging into the rest of the fixed income changes. And so that's a little less than the prior changes, but kind of within the margin of error there. So 3 steps, each one a couple months apart. And ultimately, at the end of September, we're getting to the mix A targets. And hopefully this isn't we're trying to make this very straightforward and transparent. There's no real discretion around any of the timing here. The goal is to basically dollar cost average, in a sense, into the new allocation. Are there any questions?
Any questions from board members?
I guess I have one. It might be kind of lame, but why are we adding years? I don't quite get that.
Yeah, so that is well, that's a good question. The basic change that was approved at the prior board meeting was to go from our target weights in that very first column to the last column, mix A. And so the move from the target to mix A is that's kind of noted in the far right column is called total changes. Right, in the total changes, you can see that we're taking a fair bit of money out of that short-term IG bonds bucket and moving it into IG bonds and long-term government bonds. Mm-hmm. So the net effect of that is we're taking money out of a short duration index that T-bills, those are basically 3-month cash-like bills. We're taking a lot of money out of that particular strategy and putting it into something that has a longer weighted average maturity. And so that's the US Ag line, as well as the US Long Treasury line. So those are instruments that have weighted average maturities much further out than cash. In the case of the long treasuries, decades plus, right? And so the net effect of the change from target to mix A, which was approved at the last board meeting, is an extension in duration, right? An increase in duration of the plan. And so the discussion was, well, that seems like at the prior board meeting, there was some discussion around the fact that, well, that seems like a rather large move to make in one step. And so here, what we did was split that step into 3 pieces, separated a couple of months out each piece.
Okay. So by doing that, the money needs to stay there longer. It's not like you can just go in and go out type scenario. You're committing to a longer term.
Yes. So this is all in the context of strategic asset allocation, right? And so again, at the last meeting, we discussed the fact that the strategic asset allocation for this particular healthcare trust actually hadn't been changed.
Yeah, I know.
At the last cycle.
Yeah.
And so,
Yeah.
this is a multi-year exposure, hopefully.
Okay. All right. Thank you.
Okay, thank you. Any other questions for Mr. Kwan? Well, thank you very much for Mr. Kwan and Mr. Polani for the update. Anything else under?
I just had
DA?
I just had a quick question for CIO Polani. Do you have an estimate what our current funded ratio might be
For the plans,
for the plan? Yeah.
Yeah, Prabhu, you would like me to take that?
please.
Yes, so on the last valuation, Trustee Horowitz, the funding ratio from an actuarial standpoint was just a tad above 50%. On a market value basis, it's actually about 50% right on the line. Now, of course, as Prabhu indicated, the year-to-date fiscal year returns are outstanding, and despite what he said that he may not know what will happen until June 30th, he has a pretty good idea. He want to make sure anything that happens after July 1st. So bottom line is the funding ratio is in the 50% area. So I would say 50, 51%.
So essentially no movement in the funded ratio from our last valuation?
That's correct, because as you know, the funding ratio is impacted not just by the rate of returns, but also other type of decisions, actual decisions that your board make. And as you recall, and your last valuation, your board elected to decrease the expected rate of return. And that is by itself the largest impact to the funding ratio. So any gains that we may have been able to record in any other kind of actuarial gain and losses were mitigated by the decrease in rate of return.
Thank you.
You're welcome.
Okay, Mr. Polani, anything else under oral update?
Nothing further, Mr. Chairman. Thank you.
Okay, great. Thank you very much. Item 4 is old business. There is none. Item 5 is new business. 5A is the oral update from the CEO of Retirement Services, Mr. Pena.
Yeah, thank you, Mr. Chair. So I was trying to let you know that Councilmember Davis is actually not feeling well today, so she's not attending the meeting. So just a heads up when we get to the next item. I have a few comments, if you bear with me. The first one is that April is the month where staff at the office actually calculates and apply the cost of living adjustment for Federated retirees. So they will be paid and show up in their paycheck for this month, at the end of the month, April 30th. Staff also issue all the 415 letters to those members that are impacted by 415 Internal Revenue Code limits, indicating what adjustment they will find in their paycheck for April 2021. They went out earlier as well, so they should have received them by now. We also want to let you know that we are in the final selection phase for the senior benefit analyst and the benefit analyst positions. So we expect to make offers this month for those two positions. You may recall, and we have an item for the further in this agenda having to do with a board medical advisor that we issue a request for proposal. And it actually closes today. At this point, about 10 a.m. in the morning, we have not received any bids. We did receive an intent to bid earlier in the process, but we haven't received any bids yet. So certainly we will let you know after the close of business today. I will be following up with an email, if not Friday, maybe Monday. The city council is actually going to have a study session, which is a public meeting on a Friday, April 23rd from 9 a.m. to 12 p.m. On a pension obligation bond. The pension obligation bond is a recommendation that is coming out of the Retirement Solutions Working Group that was commissioned by the mayor a couple of years ago. And so again, my email would just provide you with the agenda and the actual presentation, and will encourage you to attend the meeting as public if you would like to, so that you can share on the information. This is still very early in the process. I think the goal by the city is to eventually go back to the city council to ask them after the study session whether they would like to pursue the process of actually issuing a pension obligation bond. And the reason I will recommend you attend the study session if you have the time is because if the city does become interested and serious about this process, there are going to be some decisions that the board is going to have to make, and there's going to have to be a joint effort between the city and the boards on this process. So if you're not able to attend the meeting, that will be fine. You can always actually then go to the city website and watch the presentation. At the very least, I will try to make sure that you have the presentation slide. In closing, I wanted to let you know, you may recall, I think I shared with you that last year, our benefits manager actually was out on FMLA leave, and just wanted to share with you that she actually have presented her resignation, which becomes effective today. And so after the end of business day, I will be reaching out to our contact at the mayor's office, because along with the benefits manager, there's a couple other positions based on the budget that we would like to unfreeze so that we can kick off a search process. That concludes my update, Mr. Chair. I'm happy. Oh, by the way, and the quarterly newsletter, which I believe you had a copy on your agenda, was mailed out to all members this week. And either most of them should have received them or should be receiving them shortly. And so that concludes my update, Mr. Chair. I'm happy to address or answer any questions.
Okay, thank you very much. Any questions, comments for Mr. Pena? Well, I wish you luck in getting your vacancies unfrozen and filled quickly. Yeah.
Thank you.
In lieu of Councilmember Davis, does she have a staff person on board, or is there no update for?
There is no update, yes, at this point.
All right, so it's 10:15. We've been at it for almost 2 hours, so let's go ahead and take a 5-minute break. 10:21. Please be back by then, and we'll get going with 5C. Thank you very much, everybody. C, which is discussion on the disability retirement application process in the absence of the existing board medical advisor. And Mr. Pena, will you be kicking this off?
Yes, I will, Mr. Chair. In fact, I'll do most of the speaking of this issue. It's really straightforward. I think the one where we're going to have a lot more discussion is going to be the next one. During my update, I share with you that the RFP for board medical advisors closes today, and we had not received any bids. And in fact, we just received 1 in 10. Linda or Michelle, I think it's the first one, summary of process. Can you bring it up on the screen for a second? If you can, I wanted to make reference. I think that my only goal with the discussion this morning is, can you bring it up a little bit, please? Okay, there you go. So I want to key in on just step 4. This is sort of like, in a nutshell, the summary of the disability process. And what we're doing with the RFP is requesting a proposal for the services related to step number 4. Now, the board medical advisor has been served by Dr. Tillman over the last few years. But I wanted to just give the board, or share with the board, an understanding of the implications of not having a successful RFP for these services. I wanted to let you know that many other jurisdictions or peers of us across the state do not have a board medical advisor, and actually rely more heavily on the independent medical evaluation, which is step number 3. That particular report when making disability decisions, okay? And the reason I wanted to let you know that is because I think I mentioned this before. I was very concerned that we were not going to be successful on the RFP, and the reason for that, the reason for my concern was we have actually issued this RFP before and only received 1 bid a few years back. And let me just kind of give you some background on this. The reason why your board, Police and Fire, has always had a board medical advisor is because as part of the city structure, they actually had a doctor, they actually had a sort of like a small medical, I don't want to call it a medical group, but they did have a position for many, many years. And this doctor actually evaluated, in most cases, employees coming in that were being hired by safety, which is police and fire. And so this doctor, not only was he or she aware of the retirement disability requirements and the evidence required for making decisions by the board and issuing the report, but they actually worked with both boards for many, many years. That position was actually deleted by the city a few years back. And when we lost the doctor, we issued an RFP and actually received just 1 bid, but someone that provides similar services to other plans across the state. This person actually worked with us for just over a month and he resigned. We were just lucky that at the same time, Dr. Tillman was retiring, which Dr. Tillman happens to be the actual city doctor that held that position before Dr. Das, which was the last doctor. That's why she's well aware of the retirement requirements and the law and the municipal code. And so she was able to function and provide those services to the board. Unfortunately, her contract actually ends on June 16, 2021, and she's actually retiring now, which happens to be the day before your meeting in June. And so we were then required to issue the RFP. Bottom line here is, and I'm happy to answer any questions, if we are not successful, my recommendation is for both boards to make sure that we continue working. We still today do receive independent medical evaluations and reports. The board medical advisor actually takes those reports along with any other kind of medical evidence and then issues their report and review for the board. If we don't have that step anymore, number 4, then what that means to you is that your board will be relying on the independent medical report for the disability decisions. That's really the bottom line of this presentation. I'm happy to answer any questions. With you this morning also, we have Rose Ruquera, who is your disability counsel, and Dr. Truman, who is actually your current board medical advisors. They certainly can comment if you have any questions about this particular item. They're obviously here this morning because we do have your second phase of the disability training, and each one of them have a short presentation to share with you for that training. But with that, Mr. Chair, I'm happy to answer any questions that you board may have.
Thank you, Mr. Pena. Are there any questions for Mr. Pena on the process before we move on to 5D? Mr. Pena, just one question on my side. If we're not successful, then essentially step 4 in the process that's up on the screen goes away, right?
That is correct, yes.
So we would lose a layer of review for our final decision. Is that then, just to give me and the board a heads up, is that going to be a policy change of some sort, or will that eventually require board action to confirm this change?
We will, yes, that's a very good question. We intend to come back to you, board. I don't know yet whether it will be the May meeting or the June meeting, but we will want to make sure that both boards are clear on this, and you know, if a motion needs to be made, then we will ask for that motion to be made so that we're clear. I should also mention that in the event that we have to delete this step 4, we're probably going to be a little more specific on our request of the independent medical examiner, right, the IME, so that your board has the ability to answer the questions that need to be addressed so that you can make a disability decision. You certainly, you know, when we get to the next item and we have either your counsel speaking on his presentation or Dr. Truman, feel free to answer, you know, more pointed questions on this IME. But by all means, the IME report is not going to be the same report as you get for the board medical advisory. It's a different kind of report, but nevertheless, we will make sure to ask the questions that need to be answered so that you can make an informed decision. And I think I want to leave you with the thought that this is really more of the standard approach by our peers. They don't really have usually a board medical advisors. They do rely on, you know, medical evidence. But you know, more specifically, the independent medical examiner, which is the whole point of the definition of the review, right? It's an independent medical examiner. The person is not working either for the member or for the board. They just independent and they providing the report on the examination.
And just so that I'm clear, because I'm not as familiar, I've just forgotten. So let's say I get injured, I go see my doctors, I have my specialists, submit paperwork to the ORS. And then for the IME, what is that, like a selected list of providers? What's that resource? Just if you could elaborate.
Yes. So you may recall a couple of months back, we came before you and to extend the contracts for MedLink and Exam Works. Both of those.
That's why.
Oh, okay. Both of those offer different kind of doctors, and of course, we will reach out depending on your disability application to a doctor that is specific to the area of concern on the disability.
Okay, very good. Thank you. Any other questions, comments?
Roberto.
Yes.
Do you know why we're not getting anyone applying? Are we not paying enough? Is it just such a specialized thing? I mean, what's holding back?
It is very specialized. As I mentioned, I think my goal with indicating that this was an actual position with the city, was to sort of provide a background to the board that I think the main and only reason we had the board medical advisor is because the city had that position. I don't know if you know who Dr. Das was, but he did that for about 12 years.
Yeah, I remember. He was there.
Yeah. So, but as I mentioned, many of our peers, they don't have this step. They just rely on the independent medical examiner. It has nothing to do with pay. It really has to do with two things. You really, as a doctor, have to have a very distinct knowledge. We were just so lucky that Dr. Das and before him, Dr. Tillman, who did the work back in the 90s, had knowledge of the municipal code and the retirement disability guidelines or requirements to make a decision by the boards. So that's the first one. The second one is, let's face it, it is a lot of work, and you know, doctors, they work for a long time, and this is not something that many of them are really looking to do during their retirement. We were just lucky again that Dr. Truman showed up, and you know, I suspect that I don't want to speak for her, but she enjoyed the work, and she definitely had the skill set. So she wanted to make sure that she can offer that to the board. But again, that's why in the past, we only have one bid a few years back, and this year we have Ms. Benny. It's just a very specific skill set that is required.
Okay. Other questions?
I apologize for that noise in the background. That's our bird. I
Yeah.
apologize.
No problem. All right, well, as you jump into Mr. Pena's 5D, I'd like to note that if memory serves me correct, when I joined the HR department in '85, Dr. Tierman was a medical doctor at that time, and I'm wondering if she's going to really retire or if she's going to change her mind and stay with us.
You certainly can ask
ahead.
that question when you. So if we can jump to the next item.
Yes, thank you.
And ask Marty or Linda to bring the Rose presentation. Let me kick it off, Mr. Chair, if you may. So you may recall, as I think as Trustee Orr just indicated, and that's, you know, our fault. We do have an onboarding process. We don't spend a lot of time in disability, and you were very vocal and clear, you board, that you needed some training in this area, and so we actually had we actually had the first session of disability training for you back in January of 2021. And back then, we promised we were going to come back with a more detail and a second phase of this training, which is before you today. And so the training is sort of divided in two areas. The first one is a presentation by your Disability Council, Rose Riquera, on the disability retirement from a lawyer's perspective, the legal requirements and implications. And then the second part of today's presentation is by Dr. Tierman on the medical side of the equation for the disability process. So with that, I'll turn it over to Ross for his presentation. Good morning, Ross. Welcome.
Hi. It's a pleasure to be before everyone today. I hope if we have training in the future, we'll all be able to get together. But I'll do my best to make this an informative presentation. As you probably already know all too well, among your many complicated fiduciary challenges as a board member is to consider the disability applications that come before you. So today, I want to go over some of the legal parameters that hopefully will provide some guidelines and or tools and or just limitations to your consideration process. I hope I don't dip into lawyer jargon, but please, if I do, call me on it and demand an explanation. And also, if at any time you have any questions, please, please, please don't hesitate to interrupt. Now jumping to the next slide. Today, I just want to refresh your recollection on some of the material that you already heard back in January when the retirement staff presented an overview of the disability process. So from my perspective, the important part is that the San Jose Municipal Code provides two types of disabilities. So you can have two types of applications coming before you. And as you probably recall, one is an application called a non-service connected disability application, where the applicant can't do his or her job anymore. They have a bad disease. They suffered a bad injury and are applying. But that injury or disease wasn't connected to the job. So they apply for a non-service connected disability. The other category of disabilities, as you already probably well know, is a service connected disability. And that would encompass an applicant who again is disabled through a disease or an injury such that they can't perform their job anymore. And that disease or injury is connected to the job. And I'll describe a little towards the end what the legal standard is for that connection between the disability and the job. But the important part for me and to tell you is that the municipal code has definitions. It has a definition on disability / incapacity and a definition on service connection. And those are the ones that I want to go through today, point by point, because those will help give you the guidelines and the parameters for when you evaluate applications coming before you. And for your later reference, attached to the end of these slides are the relevant municipal code provisions, one setting forth the definition of disability and the other setting forth the definition of service connection. So we can go to the next slide. As you probably heard from your general counsel and your who is also your fiduciary counsel, that you have a number of fiduciary duties as a board member. One of those duties is to implement the disability provisions of the San Jose Municipal Code. So that's why it's important for me, as part of my training from a lawyer's perspective to you, to go over the rather complex definitions that are set forth in the municipal code that really form the framework for your consideration of any kind of application. And one point that I want to mention at the beginning, even before I dive into the specific requirements of the municipal code, is to remind you that with respect to each application coming before you, it is the applicant who bears the burden of persuading you about about whether or not the applicant has met the requirements in the municipal code. So for lawyers, the burden of proof, as it's otherwise known, or burden of persuasion, is a big deal. But it's also going to be important to you as you review an application. So the burden, so the person, it is the applicant who ultimately has to come forward with the facts that are required. It is not the obligation of retirement staff to do so. It's the obligation of the applicant. And kind of a corollary of that is that that to fulfill your fiduciary obligations, and to apply the relevant provisions of the municipal code, you can't give the benefit of the doubt to the applicant. Now, that sounds easy to say, but I certainly find in my own experience, and I've been dealing with disability applications for public sector retirement plans for 30 years. And often you will deal or arise applications where the facts are very, very sympathetic, where some really very bad disease or very bad injury has afflicted the applicant. And all of our human compassion leans in favor of the applicant. So we have kind of an internal motivation to give the applicant the benefit of the doubt. But unfortunately, under the structure of the municipal code, and by the way, this is similar to all other California public retirement plans and probably somewhat similar to all of them throughout the nation, they impose the burden on the applicant, and that we can't give the benefit of the doubt to the applicant.
Can
So
I ask a question?
Sure.
So in some prior, when we've gone over things, if the applicant has not provided all the information, or for whatever reason, when requested, for backup and, they don't feel like they can, then does that kind of shut down their case?
Well, depending on what the state of the evidence is, medical evidence, before you get to that stage. So just some scenarios. Scenario one, the applicant has not provided any evidence on incapacity. Unlikely, but that could happen. Then, unfortunately, they lose. Or, more common, scenario two, the applicant has lots of information showing they're really hurt and they can't do the job anymore. But the evidence connecting employment in the context where they're applying for service-connected disability, which, as you know, is the most common application. But so they've shown incapacity or met their burden of persuasion by putting forth lots of medical evidence on incapacity. But then the next issue is whether their employment contributed to their incapacity. And if as to that, they have no evidence, then unfortunately their application has to be denied. And in that scenario, it is very obvious they haven't met their burden of proof because they haven't provided any medical evidence. But what about the harder ones that you often encounter? And let's stick to service connection, because that's normally the much more difficult issue that will come before you. They have some medical evidence on their side, and there's medical evidence contrary to them. Let's say post June 16th, when Dr. Tierman is no longer assisting the board, and we only have, or we have the independent medical examiner who's issued a report, and you'll have that report, and you'll have other reports. And that's when, and I'll go into that a little bit later, that's when you're going to have the difficult job of trying to decide which reports are more persuasive. And an element of that is deciding, has the applicant submitted and met his burden of proof by submitting medical evidence that persuades you more than any contrary medical evidence on the issue of service connection. I hope that was helpful. I hope I didn't go on too long.
No, that's fine. But if it's not service related, it still could be a disability, and then they could still retire based on a disability, but not get the service connected disability, right?
Yes, exactly right. So So now we're diving into the, oh, and by the way, one important element that I should mention. Obviously, the San Jose Municipal Code governs. It sets forth the rules that we have to follow. Now, often you'll see medical evidence that was developed in the workers' compensation system, where the applicant filed a workers' compensation claim. And there'll be reports issued with respect to that system. Either they're sometimes known as QMEs, qualified medical examiners. There are other reports that are AMEs, agreed medical examiners. But, and those reports are often lengthy. They often go through all the medical records, but they will have conclusions that are premised on the legal terms that are relevant to evaluating workers' compensation claims based on provisions in the California Labor Code that address the workers' compensation system. But those legal terms are not applicable to us. So that's just something to keep in the back of your mind when you see those reports as part of the medical evidence that usually is provided to you in the typical application. So let's jump to the next slide where we start digging into the municipal code's definition. And unlike other systems, the definition in the municipal code of disability also includes a string of synonyms. So the municipal code definition refers to disability, but it equates that to incapacity for the performance of duty. And both of those are equated to incapacitated for the performance of duty. The main point for me is that there's a blurring, perhaps helpful, between the concept of disability and incapacity as those terms are used in the municipal code. So I normally would think, well, disability is sort of a lesser term, and only a really big bad disability would result in pinning using the label incapacity. And that, what I just said, might be true for some systems. It's not true for the municipal code. So when we refer to disability, we're also referring to incapacity. I, in my comments today, will use the term incapacity because I think that gets or highlights where we're really heading when we're doing this analysis of the disease or injury afflicting an applicant. And one thing that I'll mention now, and it probably won't seem too surprising, but we'll come back to it a little later when it'll seem a little more surprising. And that's that we need a date as to which we determine incapacity. So all the medical records, they'll either be prior to that date, some of them will be subsequent to that date, but be referring back to that date and offering opinions with respect to that date. And that's the date when we determine whether the individual is incapacitated or not. Well, what date is that normally? Normally, not always, but normally it's the date the applicant separated from city employment. So that's the date as to which we are trying to determine whether or not the individual, the applicant, was incapacitated. And if other dates are relevant, that'll be noted in the workup of the application. So you won't be left in the lurch. Let's go to the next slide. So what are some of the elements of this so-called incapacity? Well, the incapacity or disability has to be of a permanent duration or a duration that is extended and uncertain. So many diseases or many injuries, you can imagine like the loss of a leg, unfortunately. Well, that's by and large permanent. and prosthesis usually aren't adequate substitutes. Other conditions, some psychiatric conditions, some diseases, they look like they're going to go on for a while. Maybe it's not clear they're permanent, but it is clear they're going to go on for a while. If that's the case, then this element, this requirement has been satisfied. And obviously you're going to look to the medical information to determine that issue. That's one of the questions that, for example, will be asked of the IME, and the IME in his or her written report will address it. And perhaps just to state the obvious, or at least one subset under this. Well, what if there's some reasonable treatment options out there that the applicant hasn't tried them yet? Is that disability permanent or extended? Well, under relevant case law, the answer is no. If you haven't exhausted reasonable treatment options, then you can't tell if your disability is permanent or not, because if you tried those reasonable treatment options, they may succeed and they may make you better. So that's a question that is one for the doctors, and it's one that will be asked, and including the IME, and you'll have information on that. And just a sub-note on that, you might wonder, well, what is a reasonable treatment option? And as treatment options, as medical science expands and treatment options expand, that's a difficult question. But one thing that's clear, surgery, you don't have to, if you don't want to undergo surgery, you don't have to. That isn't considered under the case law a reasonable treatment option. So if you decide not to undergo surgery, then that would not be a reason to conclude that your disability is not permanent. Unfortunately, I said that with way too many negatives. I apologize. It's just not undergoing surgery won't be held against you. Well, that's two negatives. So what else? Well, obviously the next one is the one we probably should have thought would have come first. So you have to be incapacitated as a result of injury or disease. Well, that's no surprise, but that is a requirement. And notice what that means. By and large, that means you have to have a diagnosis that identifies the injury or identifies the disease. And you also might think that was obvious. Of course, there'd be a diagnosis. But as you may have already seen in various medical reports or records, a lot of times the examining physician, including the treating physician, is not sure. And they'll put things that are more like symptoms than diagnosis. So they'll say a lumbar strain or sprain. Well, that really doesn't tell you what the actual condition is. That's more a symptom. But and that lack, of course, can be remedied as time goes on, and as there's more, maybe there are more lab tests, maybe there's more imaging studies. So a situation where the diagnosis was initially not clear, that with time and more information, the diagnosis may become more clear. And then, of course, you're going to see situations where physicians differ. One physician says the diagnosis is X, and another physician says, no, it's not X. X doesn't account for this or the other symptom or lab result, and instead the appropriate diagnosis is this other. But the final analysis, we need a diagnosis. And then you can see at the bottom another important requirement. So that disease or injury has to occur while the applicant was an employee of the city. But there is So sometimes that's very obvious. The disease is first diagnosed when the applicant is an employee, or the injury occurs while the applicant is an employee. But there is another important sort of subset that often is the case. So for many applicants, they may enter city service with a condition that already exists. So if they'd had an MRI on the day they were hired, it would have been obvious they had significant arthritis in their knee from some prior injury. Or it may be obvious on the MRI that they have degenerative disc disease in various parts of their spine. We don't do those MRIs, but based on cases that Dr. Tierman and I have seen at San Jose and cases elsewhere, it's obvious that situation exists. That and often people will enter city employment, particularly if they're entering at a later age, where they don't have any symptoms, but they do have the condition. And that's where this category of aggravation will come in. And you'll hear that very often. Even though an applicant already has the condition before they were hired, if something happens on the job that permanently worsens their condition, and we'd use the label aggravation under those circumstances, then that event on the job resulting in the aggravation satisfies this requirement because it occurred, the incident that permanently worsened the condition occurred while the applicant was an employee. And by the way, just a little note on non-service connected disabilities. If almost by definition, remember it's non-service. So something happened off the job, not connected with the job. Maybe the applicant was at home repairing his or her roof and fell off the roof and suffered serious injuries. Well, that's not connected to the job, but it could result in the individual being incapacitated, no longer able to perform the duties of the job. If the applicant fell off the roof while the applicant was an employee, then that would satisfy this condition with respect to a non-service connected disability. So let's jump to the next slide. This one is sort of a more packed requirement. So this tells us that the disability or injury renders or causes the applicant not being able to perform the duties of his or her job. And in making this determination, there's two big steps that have to be demonstrated to you. And the first step is that whatever is afflicting the applicant, the disease, the injury, the broken back, the congestive heart failure, the PTSD, that those conditions have to result in work restrictions, and basically permanent work restrictions. Who determines work restrictions? In the past, it's the final analysis on that has been done by Dr. Tierman. In a situation where we have IMEs, the IME physician will be requested to answer this question and tell you what work restrictions are appropriate. And by the way, just to point out again, in the workers' compensation reports that often will be part of the medical file on any given application, they'll contain percentages of impairment. And again, those really are a function of workers' comp rules, procedures, guidelines, regulations that don't have anything to do with us. So step one, there are work restrictions. And by the way, sometimes that's a knotty issue, that there may be disagreements among physicians about what the appropriate work restrictions will be. And with the IME potentially disagreeing, including fewer work restrictions than perhaps the treating physician. That'll be another factual issue perhaps that you will have to resolve. That doesn't happen that often, but obviously it's a difficult one whenever it does arise. But let's assume that there are a set of work restrictions. Well, what happens next? What's done with those? Those are transmitted to the applicant's department. And the department then determines whether the applicant could continue to work in his or her position, notwithstanding those work restrictions. Or if they couldn't do the job entirely with those work restrictions, then whether the department could accommodate, make some changes. And let's go to the next slide. And that makes me have to mention to you just briefly something about the civil service system. You're perhaps very familiar with civil service system concepts, but if you're not, most public employers, including San Jose, have a civil service system, which means that all the jobs in the city are divided into job classifications. And then there's examinations that individuals take and minimum qualifications that they have to satisfy so that they can be hired into one of those jobs. So a fine point on this is that even if the department itself cannot accommodate an applicant in the position that applicant had with the department, if another department has that same, has a different position, but it's in the same job class, so it's basically the same duties, but perhaps it has different physical requirements, then if that job is offered to the individual and is made available to the individual, then the conclusion would be the individual is not disabled or incapacitated. Just in the same way that if the department says, yes, we can accommodate those work restrictions, then the individual is not incapacitated and the application cannot be granted. Now let's jump to the next slide. And that is merely a reminder that the municipal code definition does incorporate common sense, that the medical evidence that you're to base your decision on needs to be competent. And as you see more and more of these, you'll come to see that they're all different types of medical reports, and they have all different types of quality, that some have a lot of logic and reasoning on either incapacity or service connection. Some of them have extensive citations to the other medical records, to the medical history of the applicant, that they, in their conclusions, cite relevant lab results or relevant imaging studies. And they also cite to current medical literature. And in those situations, that would be a really good medical report. And if it came out to a certain result on, for example, service connection, and there were other medical reports that didn't have all those attributes, then it came out to a different decision, you'd be well advised to base your decision on the better, more medical evidence, the so-called competent medical evidence. And remember, the burden of persuasion is on the applicant and to produce competent medical evidence. Now let's jump to the last requirement, and it's in some sense the hardest but the easiest to summarize. So if we could jump to the next slide. This is service requirement, a connection. And based on California Supreme Court precedent, the actual question on service connection is the following. Did the applicant's employment with the city contribute in a real and measurable way to the applicant's incapacity? That's the question we'll ask the physicians. That's the question ultimately for you to resolve. And notice it uses those words real and measurable. And I don't think any of us would think those are the most precise terms that could be used. But unfortunately, under California Supreme Court precedent, those are the terms we have to use. And with real meaning actual and concrete, not speculative, and measurable means verifiable and having a basis in medical fact or in reasonable medical inference. And by the way, that question, the key question, that did the applicant's employment in San Jose contributed in a real and measurable way to his or her incapacity, has also an aggravation element, because often there's a pre-existing condition. So the service connection question, the $64 question in an aggravation context would be, did the applicant's employment with the city of San Jose aggravate, in other words, permanently worsen in a real and measurable way the applicant's incapacity? Similar question, but modified to the aggravation situation. So let's go to slide 9. We're in the home stretch now. And unfortunately, these are just words. But often you're going to be presented with situations, particularly in diseases or conditions, degenerative disc disease, heart disease, where there's a multitude of work and non-work factors, with the non-work factors including genetic indications, issues of just getting older. And the points to remember is that the work factors, when you're trying to compare and weigh on some invisible weighing mechanism, work factors from non-work factors, the work factors do not need to be primary. They do not. They do not need to predominate. They do not. They have to be more than infinitesimal, which I assume you already knew. And so the bottom line is the work factors have to be substantial. So that even if there's a lot of very substantial non-work factors, if the medical records indicate that the work factors are substantial, then that application satisfies the service connection requirement. It satisfies the real and measurable standard. Now, you're going to find some tough ones where someone doesn't have any symptoms, and then all of a sudden something that I think all of us would say was a minor work event occurs, and then the symptoms occur. Well, you're going to have to decide, and again, with the help of the medical records and the report of the IME, whether that work event could be deemed to aggravate the condition or merely reveal it. In other words, that condition was just waiting to happen. It wouldn't have taken a big deal. It could have happened off the job, on the job, but it cannot, in a fair sense, be seen as this event as a real contributor, because the work event was minor. The condition was just waiting to happen. You'll find those because a lot of diseases just progress on their own, as Dr. Tierman will discuss, and really have no relationship to anything else, including work. Now, just jumping to the second to last slide, this is to remind you the obvious: medical knowledge changes, so what's competent medical evidence changes. And one example is the medical understanding of cumulative trauma, let's say 20, 30 years ago, is different than it is today. It hasn't vanished, but it's not nearly the concept that it was then. And one example of that is the intervening twin studies, where a sedentary twin develops the same bad back that a physically active twin develops. So when the physically active twin comes before you with an application, then and says, well, it was the job that did it. And by the way, I'm assuming no, at most only a minor event on the job. Well, the fact that the sedentary twin also would get it suggests that what happened on the job wasn't a real contributor to the back problem. So just to end, the next slide, the last slide, this is a difficult standard to apply. The real and measurable standard is difficult, but the burden rests on the applicant. And as the final takeaway, ultimately, you have the discretion on this issue and the other issues that I've talked about. It's a discretion which you must exercise reasonably, but it is discretion that you possess. And that's all I have.
Thank you, Ross, for the presentation. Any other questions or comments by the board before we go to Dr. Tierman?
I have one. It might just be a one-off scenario, but I know I work in Parks, Rec, and Neighborhood Services, and we have a lot of people who do work out in the, maintenance people, gardeners, all those kind of people. And so they do some heavy lifting. And there are times, and these are worker comp issues, where they're out there and they've strained their back or whatever. They can't do the work anymore. And so they're looking, or they're just recovering and they look for office work or things like that. And we had a particular person who couldn't do the work anymore. And that job class the person was in was a gardener. That person came to the floor and could do office work. And in the meantime, did a very good job and managed to become, applied and got a different job classification. Now, as far as I know, that person never applied for disability retirement or any of the other stuff. But that person did go to a different job classification, like an office specialist, and did a very good job. So what about situations like that? Because you said it has to be within the same job class, but sometimes those job classes, people can find other things, maybe want to find other things. I guess maybe you never see it because they never put in disability, right?
Let me try to address that issue, give you the non-attorney perspective. I'm afraid that if we let the attorney speak, we'll be here for a long time. So first and foremost, the number one issue, Julie, that's the kind of employee that we want to see, right? You even said they didn't even apply for disability because they wanted to work. Ideally, that's how things will work out. In a situation where we will get a disability application, your board will have to find this member disabled because he is not able to do the work within his job classification. Now, they may still want to continue working and agree to do specialist work. That's beyond the point, and then they will not be getting the disability retirement because they're still working. But if they say, I cannot do any other kind of work, then they're going to get a disability. That's the short explanation of it, but that's how it will work out.
Okay, all right.
I mean, I obviously, if the attorneys have a different point, please feel free.
No, say just two little subpoints to that. First, if the gardening position, if they had a modified duty position that was permanent, and then in other words, could accommodate the work restrictions, then there was a job for that individual, and if the individual applied, the application would have to be denied. But jumping to your scenario, if they had, if they're doing office work and actually applied, took the exam or whatever, met the minimum qualifications and were appointed to that position, then that now is the position. Gardner is out of the picture. So it's only if they're incapacitated from the performance of duty of the management analyst or clerical position that matters.
Okay. All right. Thank you.
All right, thank you for the question, Trustee Jennings. Dr. Treeman, your turn. I know you've been looking forward to this presentation. You have 2 more months to work with the board, but you know, I get the impression for the board that if you decide to change your mind, we wouldn't be upset about it. Anyway, Dr. Treeman, I'll turn it over to you.
Thank you very much. I'll try to keep this briefer than I thought it would be originally, because Russ actually addressed a lot of those points that I have in my presentation from a medical standpoint. Most of the time, when a service-connected disability retirement is accepted by the disability committee, it goes on a consent calendar, and it's only if an individual trustee wants to have more information that it's taken out of the consent calendar and heard. So the cases that you are hearing are cases that have been denied, or the very, very rare cases when the disability committee can't make a decision and wants help from the board. Next slide. So what you want from a medical consultant, whether it's someone like me or an independent medical examiner, is to answer 2 questions. Incapacity. That's defined as, are there objective measures of incapacity? And if yes, what are those work restrictions? As Russ has said, if there's no work restrictions, then there's no disability. Causation doesn't matter. But if there are work restrictions, we need to consider causation. And the basic question is, are the injuries or illnesses listed by the employee, and many times they have a whole list, are they work-related according to the San Jose Municipal Code? Next slide. So before I get into those questions, how does the medical consultant or IME get their information, and what do they look at? Retirement services is really good, even though the burden of proof is by the employee. Retirement services does a Herculean effort to get the pertinent medical records for the employee. And I think it's a wonderful thing, especially for Federated, where a lot of them don't have attorneys, and a lot of them don't have the savvy, especially in some of the more manual labor, to actually get all of this stuff. So they get the accident reports from the department. They get workers' compensation claim forms. They get all the worker compensation documents that they can get, including physician treating reports, AME, and QME reports. And if you do have a medical consultant, I will also have the IME report that Retirement Services sends out at their request to make an opinion on these injuries. Next slide. These are challenging because a lot of times records are not always complete, and sometimes they're missing. The IME usually belongs to like ExamWorks, which you asked about, which are a panel of physicians. It's not their full-time job. They're usually orthopedists who are treating, have busy practices, and use this as supplemental income. And 99.9% of the reports that they write are workers' compensation reports, and they follow different rules, as we have been told before. And a lot of times it's very difficult for the IME to shift gears because that's what they do all the time. And they are similar enough for them to sort of follow that form, even though we give them a whole letter and ask specific questions. The other thing with these big groups is that the medical records are often reviewed by a medical assistant. And that means that she or he writes the medical review portion of the report. She is the one or he is the one who's taking out what they think is pertinent information. And the reason why I think this is important is that the IME may miss discrepancies in the medical history. For example, they might miss that someone had an injury that he reported 30 days later and didn't seek medical treatment 60 days later, till 60 days later. That's very pertinent. If you have a significant injury, you would expect that they would report it right away, or at the very least, see a doctor within the first couple of days if it's significant. Next slide. So what is incapacity? This is from a medical standpoint and not a legal standpoint. It's the marked loss or deviation in physiologic, psychological function, or anatomic structure in the body. It's used to determine work restrictions. Now, from a medical standpoint, it consists of 3 factors. One is risk, second is capacity, and the third is tolerance. Next slide. What is risk? Risk is defined as, does the employee, if he goes and does his job, might harm his coworkers, and especially in the city of San Jose, the general public. It is also something individually that a person should not attempt because they are in pain and have greater odds of even more injury. Next slide. Capacity. This is the patient's current ability. What should it ideally mean? It should include what their strength is, what their flexibility is, and what is their endurance. Also, which Russ touched upon, the board must agree that the employee has reached maximum medical improvement before disability job restrictions are approved. Next slide. MMI is what we call it. It's where an employee reaches a state where his or her condition cannot be improved any further, or when a treatment plateau in a person's healing process is reached. It's once this is reached, the treating physician is saying, no other reasonable treatment can be done to help this patient, and the work restrictions are now permanent. Next slide. So what you have to look at is, did the consultant answer the questions of need for and type of work restrictions based on objective findings? Number 1, did they discuss, was there a risk of a substantial harm to the employee? Or did the employee just say, look, it hurts when I do this. I can't stand more than 15 minutes. I can't walk more than 20 minutes. Was the patient able to do the essential functions of the job based on ability, not what the employee states that he or she can or cannot do? And again, the last one, is there substantial harm and is there evidence of loss of function? Then there is impairment and the work restrictions are indicated. To take something simple, if someone could only lift their arm this high, they can't be expected to shelve things that are 10 feet above them because they can't reach their arm about, because they physically can't do it. Not because they say it hurts when they do it or I get tired when I have to do it. So if the answer is no to these questions, then the consultant must look at the employee tolerance. And what is tolerance? Next slide. It's the subjective complaints of ability to do the job in question. They say they're unable to perform the job, but when they do a physical exam, the physician, there's really no objective or very little objective evidence of loss of function. The employee says, I really can't do it because it hurts or I get tired. Unfortunately, fatigue and pain are real, but they're not measurable. All of these pain questionnaires are all subjective, and you can have the same person on different days give wildly different numbers of how much they have pain, depending how the question is asked. So if the medical reports and the IME give work restrictions based only on subjective complaints without meaningful objective findings to corroborate, then the medical restrictions are based solely on the employee's report of impairment. And that means we don't need a doctor. You can just bring them up and say, what can you do? What can't you do? Because that's what the doctor is essentially doing. If the medical consultant, however, believes that there still may be valid work restrictions, then the consulting physician says, I know the objective findings might not raise to work restrictions, but these are the extenuating circumstances and why I still believe that there still must be work restrictions. A lot of times you'll see a consultant say, it is my medical opinion, or I've been a doctor for 500 years, and therefore I know what I'm talking about. That is not real and measurable. They cannot use that as a reason for medical restrictions. The Board or Disability Committee should ask questions, and I can tell you the Disability Committee always does until they understand why these work restrictions are or should be in place. Next slide. So now, if we have the work restrictions, we move to connection and causation. That is, did something at work, the cause an effect that is scientifically valid and reasonable? In other words, was the injury really work-related? Next slide. Again, accidents are easy. Someone falls, breaks their leg, cause and effect. Illness or cumulative trauma is much harder. The doctor must determine if there's a real and measurable risk, if the disease is characteristic of and peculiar to a particular occupation. Now, some of these are easy. Coal miners get silicosis. It's part of the job. Cumulative trauma injuries are much harder to ascertain. Most of the times when they biopsy tendons of people who have cumulative trauma, they're normal. They're not even swollen. There is no anatomical thing you can point to. The other thing is carpal tunnel syndrome is very ubiquitous, especially with these risk factors, pregnancy, obesity, and diabetes. So did work contribute it or didn't contribute it? Next slide. So you really want the medical consultant to really make a true assessment of work-relatedness. Russ said this before, did the doctor make the correct diagnosis? If you don't have the right diagnosis, how can you determine work-relatedness? Did the doctor cite available epidemiologic evidence for a causal relationship? And did the doctor really attempt to assess the evidence of exposure? Or again, did they totally rely on the employee to give them the assessment of their exposure? And I'll give a very quick example of one patient who bamboozled me, not on purpose. It was because of my misconceptions. He said he had to load computers all the time. And this was back in the 80s when, you know, the computers were big, bulky, and heavy. Then I called the employer and he said, oh, they're just doing these small little laptops that weigh 8 pounds. And he only has to pack 5 an hour. That's a whole big different picture than what I envisioned from what the employee told me. And did the doctor consider factors outside of work and the prevalence of diagnosis in the general population? And this is really important. A lot of the epidemiological studies are done like in gardeners. They have a lot of back pain. And the original study said, wow, look at that. 60% of gardeners have back pain. They have a really high prevalence. It must be due to work. But then someone went out and compared gardeners to the general population. There was no difference. Same amount of back pain. Next slide. Other factors to consider. Russ, I think, really did this well, so I really won't go into it, is aggravation versus exacerbation. And again, you have to be careful because so many people, and it starts earlier than we think. Now there are studies that have shown that degenerative disc disease can begin as early as 8 to 10 years old. So it is a disease that sort of happens throughout life and progresses throughout life. Next slide. What is hard is the patient really believes that it's work-related. They said, I never had this hurt before. I didn't have an accident causing this before. It never hurt before. However, that does not mean objective aggravation. It can mean that a causal relation has been erroneously assumed from a merely sequential one. And Russ touched on that degenerative disc disease is a continuum. And you can look at some x-rays of people where the back looks like hell. And any of you who've had an MRI have said, oh, the doctor said I had blah, 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 blah. But we don't know if that's the pain generator or not. Degenerative disc disease goes on for decades, and then sometimes it starts having pain, and in other people, and we don't know why, with equally horrible looking backs will not have any pain. Next slide. There's a problem with temporality, and again, Russ touched on this. A woman walking up the stairs felt pain in her right knee, stated never had this pain before. No injury, didn't twist her knee, didn't trip. X-ray shows knee osteoarthritis. Is walking upstairs the root cause of her pain, or is the underlying pain due to osteoarthritis? The pain happened at work, but the work did not cause the knee pain. Next slide. Other considerations. Nearly 100% of the medical records are from claims that have been accepted from the workers' compensation system. The laws and regulations are quite different. Incidents that happen at work almost are universally declared work-related in the workers' compensation system. And that has a lot to do with the original trade-off that a worker can't sue the employer if the employer takes responsibility for the work-related injury. So when the first episode of back pain, shoulder pain, knee pain, etc., occurs with normal activity at work or minimal trauma at work, the workers' compensation doctors and a lot of the IME doctors will assume that it was intended to be work compensable, even if they understand on a lot of levels it was not actually caused by the work exposure. Next slide. And again, we talked about progression of underlying disease. And we'll skip this slide unless anyone has any questions on it. This is the same thing. My hands go numb when I type on the keyboard, therefore the keyboard is the cause of my carpal tunnel. Actual studies have shown insufficient evidence between typing and carpal tunnel syndrome, despite since the 70s, over 50 years of trying to prove it. Do we grant service connection? Next slide. I'm just going to do very quickly about mental illness causation. It's essentially the same, but some of the things that are very different about mental illness is that we cannot just take the reports of the treating physician. Professional standards and ethics codes prevent treating physicians to deal with forensic issues such as causation. And this is both for psychiatric and psychological association. And that's because trust is so important in forensic psychiatric evaluations. If you don't trust the doctor who's saying, I don't think it causes it work, how can you have a therapeutic relationship? Next slide. The other thing is you have to go in more detail with these to have a good evaluation. The modern standards for mental illness diagnosis must comply with the standards of the American Psychiatric Association and not deviate from the Manual of Mental Disorders. And the evaluations need to include general medical records, mental health history, employment records. These past records are critical, and often we cannot get employment records. It's very, very difficult. Next slide. The steps are similar, but there's some important things. Epidemiologic evidence is lacking in the literature that links mental illness to a definitive cause. So, and a claim must be grounded in credible and reliable scientific findings that the specific claim caused and is a significant risk factor for the diagnosis and is a reason for impairment. And there is no scientific validated method for diagnosing specific mental illness. It's a constellation of symptoms. There's no MRI, PET scan, blood test, etc., that can tell you you're mentally ill and what your exact diagnosis is. Next slide. Again, no critical report should rely solely on the examinee. You need to evaluate for personality disorders because that causes a lot of conflict within the workplace. And when evaluating impairment, you should use established analysis and not use an evaluator's impression or clinical experience. Next slide. Just in general, the medical consultant or IME needs to review each case in detail, taking on all the elements that we say before, and use medical evidence, including the medical literature, to give reasoned opinions on impairment and causation. And now, Jay and Roberto, I want to know, because this has gone on a long time. I do have a small section on epidemiology. I can skip it if you feel you have enough information and go to questions, or if you want me to go through those slides, I'm happy to.
Roberto,
It's up to the board. This is your training. Whatever your desire is, we will do.
Well, let me ask. So, thank you, Dr. Chairman. Good to see you, and Mr. Requeta too. So, as I listen to the information, it's certainly complex, but still seems intuitive as you say it. It makes sense. And at the same time, I know that, well, the board sees certainly a minority of the disability retirement applications, but the ones we have seen lately, part of what's driving the training is that despite staff recommendations, staff consultant recommendations, I believe last couple of times the board has unanimously voted to go in an opposite direction. Mm-hmm. So there's something missing. There's something we're not making the same, we're not evaluating them the same way. And so is that something we want to try to address head on right now, or is that something, Mr. Pena, you were thinking about another step in the training? We did something last year. We're doing this today. Is there because at some point we need to get at that.
Yeah.
Why are we doing that? Why is that happening?
Yeah, we would like to understand that as well. Well, I think part of it. Let me just say two things. First one is this is a very difficult subject, and I think to the board's point, you didn't have a lot of training. The truth is that the new board, right, did not have probably the training that was needed. Your prior board really have two members, if you recall, that have a lot of disability knowledge, and used to be your former chair from Matt Lodge, and also the former director for the retirement office. So I think in the past, the board relied heavily on their understanding and background. Obviously, both of them are gone. And, one of the reasons that we are providing this training, the first phase was in January, and this is the second one, is because of the request by all of you that you needed training because you didn't feel that you had the the information and the tool set to make informed decisions. So I think that's one of the reasons for the difference of opinion between your board and staff. The second one, they were very difficult cases. They were very difficult and challenging cases. So I think it could have gone either way. I can tell you that my approach to this situation is twofold. I think that the training should be a never-ending annual reminder of what disability is. The second one, really, I thought it may be a good idea for your board to start thinking about perhaps considering creating your own disability committee. And the reason I say that is because once we provide the training, number one, trustees will be better informed and educated to actually make decisions on disabilities. But number two, I think if you have a committee that is formed from your own peers, I think your board will be probably more likely when the situations and the cases come before your board to be more consistent on your decisions. Having said that, let me just make a couple of comments about working with Dr. Truman and what I have learned over the last few years. I've been obviously in the industry for 25 years and work in disability for many years, making decisions, recommendations to the boards. And I have learned two things working with Dr. Truman. The first one, I have to say, she's absolutely right. There's a huge distinction between workers' comp and retirement for the municipal code or the state in California in terms of disability retirement. There are two different guidelines and requirements, and I think she's absolutely right on that. On cases of the city or the employer is much more willing to support that. And those doctors always, when they do provide a disability, that's where you hear the expression is a 37% disabled or 51% is because they actually assign percentages. In your case, you have to make a decision whether or not the person is disabled. The second one is that I have learned with information provided by Dr. Truman that where many, many years and in the past, there was an understanding that actual physical work impacted disabilities. She has brought enough case studies and information in the medical science to support that sort of knowledge. And Dr. Truman, feel free to make sure that you make this explanation better than I do medically, that is not as much of the case as we thought. And that was the example that the Council Riquera provided on the study of the twins. That one of the twins was sedentary. I mean, did not make any much physical work, and the other one did, and they both developed the same back problem. And so that's just a classic example, right? So members tend to think because something hurt, by the way, my back has been bothering me for the last 8 years as I joined the office, but I don't think it's the job. So we have come to learn that it's not as much the actual physical activity as it is in many instances, if a situation of that may have been developed because of family history. So I don't know how well you can explain that, Dr. Chima, but that's something that I have come to learn just over the last couple of years that I think is really a challenge for anyone when they're making a decision. So in summary, Chair Castellano, I think the one approach I will suggest your board consider is, again, first determining whether or not creating a disability committee of the board is something that you want to consider. And two, the willingness to, of course, make sure that we provide some sort of an update on disability training every year. Not to mention, obviously, that these presentations are available to you going forward, and we'll make them part of the policies and procedures that we have. in the application confluence so that you can refer to it whenever you have to. So I know it was a winded and long answer to your question, but I just wanted to make sure that you heard what my thoughts were on the matter.
Well, I also think that one of the items that Russ provided was an applicant is not to be given the benefit of the doubt, that is fiduciary responsibility. And so, because I remember that. It wasn't unanimous because I did vote not to go forward. And usually I tend to be more sensitive in these issues. But I didn't totally know all this at the time, so I wasn't as knowledgeable in the facts. But I think I think we tend to have that sensitivity to people, and we acted more on, in my opinion, we acted more on that versus some of the guidelines and what the rules are. So, you know, and so yes, having this document is good. If we have a separate, it's really up to the board members if they want to have another committee, where we go forward. I suggest if we do that, since we're all still kind of new, I mean, that, we have maybe Russ sit in at times, as legal counsel, just to, steer the boat a little to make sure we're not going off. But anyhow, that's my 2 bits.
Yeah, just to address that issue, Trustee Jennings, if your board end up putting together a disability committee, you'll have Ross will be the disability committee attorney and staff. Obviously, will be sitting in all the meetings, just as we do with police and fire, and provide answer questions and provide input. The only difference will be, again, that you will not have Dr. Thurman sitting, because again, if we are not successful on the board medical examiner RFP, then it will be more relying on the independent medical report examiner report IME. So Jay, I don't know if I answered your question. Well, I know it was a long-winded answer, but
Yep. What process would you envision for having the board consider a new committee?
This is something that as part of the discussion today, you can either direct staff to either bring back an item for discussion, and we can address it that way, or any other given time that your board is ready to consider that discussion. Then when we have our agenda review meetings, Chair Castellano, that particular item could be requested, and the staff will bring it forward, and we'll do whatever. We'll probably provide some idea as to how that process works in police and fire, although you don't have to follow the same procedure, just so as a base guideline for the committee work. I will also suggest you do have a vacancy right now, so obviously there's going to be some more decisions that you're going to have to make in terms of committee participation. So you will want to make sure that your board is complete, and you do have that public member position filled before you start thinking about creating any other committees.
Yeah, I'm definitely open to the discussion, and I'm not sure how much we need to wait for that vacancy, because we've had discussions about it could be vacant until the term expires and then we get the new person. We don't, as far as I know, we don't know the answer to that question yet. But also, I wasn't sure about where if we initiate that conversation through the board, through governance committee, and maybe we need to talk about it offline. But if for the sake of the other board members, if you already know what that process would or should look like, then I'd want them to be as up to speed about it as me, not just you and I having a conversation through agenda review. But if we need to have the discussion, initiate the discussion through the next board meeting, that's fine. Any other thoughts from other board members about either the presentation, either the information today or next steps?
I'll just share a couple of thoughts to say thank you for these documents and the presentations. They are detailed, but it's really thorough and very helpful. You know, when we're faced with the disability assessment, I don't have a strong opinion. I'm rather agnostic at the moment, but I guess I'm leaning towards the fact that having us all involved as we have been there's an advantage in that we keep this topic top of mind at the front, you know, that we're getting a little deeper and learning a bit faster. My sense is if it goes to a committee, if indeed we go down that route, it will sort of get, you know, delegated away, which again, 6 of one, half a dozen the other. But for now, I'd have a preference to stay engaged so that I understand the nuances and try to you know add value to that discussion.
Mm-hmm. Yeah. Thank you.
So a comment to that, trustee, or thank you for those comments. That makes sense. The board will still be involved. The committee of the board would just take over the work by the committee by staff, and so the committee will still, it's like investment committee. They will make recommendations to the board, and just like the staff committee today. The item will come before your board for discussion, either on consent, in which case it's a consent item and your board can approve it. And if there's no recommendation, or if there is a recommendation of no approving, then it will be a discussion item. So your full board will still be engaged in the discussion and the decision making. It's just that the pre-work or the initial work is not being decided or recommended by staff, but by a committee of your board.
Thanks for clarifying. That's helpful, really helpful.
Other thoughts?
I just wanted to thank both Dr. Chairman and Council Requeda for these comprehensive presentations. I think it gives us a lot more information than we had before. And echoing what Trustee Jennings said, I think a big source of, well, it was a revelation to me to learn that the benefit of the doubt does not go to the applicant. And I think had we known that, some of our earlier votes, what it may have gone another way. So I think maybe to your question, Jay, some of the reasons we've overturned staff is because we were giving a bit more weight and a bit more credence to the applicants, even when evidence was missing or their presentations were incomplete.
Yes, I agree.
So I guess I would say if we're not going to do a separate committee and set that up, then what we should do is before these come forward to the board, we take Russ's presentation and take a few of those major caveats and put it on one sheet, okay? And we put that in front of everybody. So we just remind each other again, these are the guidelines, guys. This is what we got to do. And then he should be there when we're reviewing, just to keep us on task with that. So we're following what it is. That would be my suggestion.
If I may, Chair Castellano, I think you indicated, but you know, I will want to make sure that the board have the full support. I think you're suggesting maybe to bring an item back for discussion to a future board meeting, whether it's the May meeting or June, to consider whether or not to establish a committee and staff to prepare some work that would allow providing some basic guidelines as to how that committee will work. If that's what your board preference is, all we will need will be direction from your board to do that. And if your board is pretty clear that that's not something that you want to entertain, then let us know and that will be fine. But yes, to Trustee Jenny's comments, obviously we'll have Disability Council available for all the board meetings. Again, the difference is if there is recommendation on consent, he won't be available because it would be expected to be approved on consent. But if there's a discussion item, he certainly will be available to answer questions by your board.
And my inclination is, and I'm checking with the board now, is to, yes, provide direction to staff to bring back in a future agenda item to discuss what the world would look like with the disability committee, the new disability committee, without our own medical opinion, dealing only with the IME. Yeah, let's take a look at that. So I mean, and also Trustee Jennings mentioned Mr. Keita's information, and I agree, his stuff was great. And item 5C does include a attachment with guidelines, and I didn't reconcile if most of it is there already. That's great, and if not, then perhaps that's a place to codify the information. I'm guessing most of it was quoted from the Muni Code, so in some form we were already working with it. But does anyone have any objection to providing direction to staff to bring back a future item to discuss the disability committee, the potential of a disability committee? Okay, so I think is that a no, like no objection, or no, we don't want to?
No objection.
No objection. Okay, all right. So
Thank you.
Yes, thank you very much. Again, thank you, Mr. Ikeda. Thank you, Dr. Tierman, for being with us today. It really is great information. So I really appreciate that.
Yeah, and Dr. Tierman, again, if you change your mind, we won't feel bad about it. So just let us know. You still have time.
Yeah, I agree. All right. Let's go on to item 6 on the agenda, committees, reports, recommendations. 6.1 is the investment committee. We did not have a recent meeting. Next meeting is on later this month, April 20th. Trustee Chandra's not here. Trustee Orr, is there anything to say under 10A, 6.1A? Again, we haven't had a meeting, I know,
Yeah,
but
for
I
the
just want to
investment
provide
committee,
opportunity.
No, it's exactly the same update as from last time. There's
Okay.
nothing to report. Thank
Great.
you.
Thank you. 6.2 is governance committee.
This,
yes.
yeah, we had already discussed our last meeting at the previous full board meeting, so there's
Thank
nothing
you.
to report here.
Very good, thank you. 6.3 is the audit committee, same story, I believe. Is that correct, Trustee Kelleher?
Yeah, the only update is that we are signing an engagement letter for Grant Thornton. So we're basically good to go.
Okay, yeah, very good. Thank you for that. For the update and for the work with Grant Thornton. 6.4, Joint Personnel Committee. Last meeting was November 10th, no new meetings. Any comments, Trustee Orr?
At this stage, we won't have anything to report until the JPC reconnects.
Okay.
Yes, that is correct. And we're trying very hard to see if we can schedule a meeting for later this month, if not early in May. That's the goal.
Very good. Thank you. Item 7, education and training. We have the 7A is the Cortex report, Calipers virtual trustee roundtable, May 10. SACR's virtual annual spring conference is C, and D is the Calipers virtual advanced principles training in June. Any future agenda items? Okay, moving forward, any public or retiree comments? All right, with that, we're adjourned. Thank you very much, everyone's great staff work, and great to see all of you as always.
Thank you, everyone. Have a good rest of your day.
Next month, yes.
Be well. Bye.
Okay.
Bye, everyone.
Bye, everybody.
Bye-bye.